The marble columns of the Supreme Court chamber seemed to close in around Congresswoman Jasmine Crockett as Chief Justice John Roberts leaned forward from his elevated bench, his piercing gaze fixed on the young representative who had dared to question the court's recent voting rights decision during a congressional oversight hearing. Roberts, with his silver hair and commanding presence that had defined 17 years leading the nation's highest court, adjusted his black robes and prepared to deliver what he clearly intended to be a career-ending rebuke to the freshman congresswoman from Texas. "Representative Crockett," Roberts began, his voice carrying the full weight of judicial authority. "Your recent statements about this court's decision in Millfield versus Georgia demonstrate a fundamental misunderstanding of constitutional law that raises serious questions about your fitness to serve on any committee with oversight responsibilities over federal courts." The packed gallery fell silent as constitutional scholars, legal reporters, and congressional staff watched what appeared to be an unprecedented judicial destruction of a sitting member of Congress. Completely unaware that Crockett had spent the past 6 months methodically documenting Roberts's own contradictory statements about judicial authority, constitutional interpretation, and the proper role of congressional oversight. Chief Justice Roberts commanded respect from across the political spectrum as the longest-serving Chief Justice since Charles Evans Hughes, having guided the court through some of the most contentious legal battles in modern American history. His Harvard law background, his years as Principal Deputy Solicitor General, and his reputation for institutional preservation had made him one of the most influential legal figures of his generation. When Roberts spoke about constitutional interpretation, senators listened, law professors quoted him, and even his critics acknowledged his profound understanding of legal precedent and judicial authority. Representative Jasmine Crockett, at 43, had built her reputation as a civil rights attorney before entering Congress just 2 years earlier. But what most observers didn't realize was that her undergraduate work had included extensive constitutional law studies followed by a judicial clerkship that had given her intimate knowledge of how federal courts operated. Her assignment to the House Judiciary Committee's court subcommittee had been viewed by some as premature for a freshman representative, but Crockett had quickly demonstrated a sophisticated understanding of federal court administration and constitutional interpretation that impressed even veteran committee members. The confrontation had been building since Crockett's appearance on Meet the Press 3 weeks earlier, where she had criticized the court's decision in Millfield versus Georgia, a case that had significantly restricted congressional authority to oversee federal court operations. The majority opinion in Millfield, Crockett had stated during the interview, fundamentally misreads the separation of powers by suggesting that congressional oversight of court administration somehow threatens judicial independence. This represents a radical departure from 2 centuries of precedent recognizing Congress's legitimate role in ensuring accountability across all branches of government. Before we reveal how Jasmine Crockett's evidence completely exposes Chief Justice Roberts's contradictions, make sure you hit that subscribe button and notification bell, because what happens next will shock you about judicial hypocrisy. And we've got more incredible political investigations coming your way. The criticism had generated significant media attention, with several legal commentators defending Crockett's constitutional analysis, while others suggested that a freshman representative shouldn't challenge Supreme Court decisions so directly. Roberts, who typically avoided public responses to political criticism, had made the unusual decision to address Crockett's comments during this oversight hearing, seeing an opportunity to defend the court's institutional authority while demonstrating the consequences of what he viewed as uninformed constitutional commentary. Representative Crockett, Roberts continued, his tone growing more authoritative, your statements reveal a troubling misunderstanding of the constitutional relationship between the judicial and legislative branches. The Millfield decision merely reaffirmed principles that have guided this court for decades, that judicial independence requires meaningful separation from political oversight that could compromise the integrity of our constitutional system. He paused for effect, allowing his words to resonate through the chamber. Your suggestion that Congress should have broader oversight authority over court operations demonstrates exactly the kind of constitutional confusion that makes effective governance more difficult. Crockett remained composed as she reached into her leather portfolio, her expression calm despite the magnitude of the judicial criticism she was facing. Chief Justice Roberts, I appreciate your perspective on constitutional interpretation, and I certainly respect the court's institutional authority. However, before we continue, I'd like to address some apparent inconsistencies between your current position and statements you've made in other contexts about these same constitutional principles. Roberts's expression shifted slightly, a subtle tightening around his eyes that suggested he wasn't expecting Crockett to challenge his constitutional analysis directly. I'm not sure what you're suggesting, Representative Crockett, but I can assure you that my understanding of separation of powers principles has remained consistent throughout my tenure on this court. I appreciate that assurance, Chief Justice Roberts, Crockett replied, organizing her documents methodically. That's what makes some of your previous statements particularly interesting to examine. For instance, in your confirmation hearings in 2005, when Senator Biden asked about congressional oversight of court administration, you stated, and I'm quoting directly from the transcript, Congress has not only the right, but the responsibility to ensure that federal courts operate efficiently and accountably. Judicial independence doesn't mean judicial immunity from legitimate oversight of administrative functions. She displayed the confirmation hearing transcript on a screen visible to the gallery. Yet in your majority opinion in Millfield just last month, you wrote that congressional oversight of court administration threatens the foundational principle of judicial independence. These positions seem directly contradictory. Has your understanding of constitutional separation of powers changed significantly since your confirmation? A murmur rippled through the gallery as observers recognized the precision of Crockett's citation and the apparent contradiction she had identified. Roberts shifted slightly in his chair, his confident demeanor showing the first signs of uncertainty. Representative Crockett, confirmation hearings and judicial opinions address different legal contexts. The principles remain consistent even when their application varies. I understand that context matters, Chief Justice Roberts, Crockett acknowledged respectfully. That's why I've brought several other examples to help clarify the consistency of these principles. In your 2018 speech to the Federal Judicial Conference, you stated, "The federal judiciary benefits from congressional oversight that ensures proper resource allocation and administrative efficiency. We should welcome such oversight as a sign of healthy institutional relationships." She turned to a new page in her materials. Yet in yesterday's Washington Post interview about the Millfield decision, you said, Congressional oversight of judicial administration represents a fundamental threat to constitutional governance that the founders specifically sought to prevent. Again, these positions appear to be directly contradictory. Which statement reflects your actual view of congressional oversight? Roberts's discomfort became more visible as he struggled to reconcile these contradictory statements. Representative Crockett, these quotes may sound contradictory when taken out of context, but they address different aspects of the complex relationship between congressional authority and judicial independence. I've provided complete context for each quote in the materials I submitted to the committee. Crockett responded calmly. But let's examine another area where your positions appear inconsistent. In your testimony today, you criticized my fundamental misunderstanding of constitutional law. Yet in this letter you wrote to the House Judiciary Committee just 14 months ago, you praised my sophisticated constitutional analysis and nuanced understanding of separation of powers principles. She displayed the letter on the screen, causing another wave of reaction through the gallery. The letter specifically commended my work on judicial oversight issues, stating that my approach demonstrated exactly the kind of thoughtful constitutional analysis that strengthens our democratic institutions. Has your assessment of my constitutional understanding changed dramatically in the past year, or are these contradictory evaluations? The tension in the chamber intensified as Roberts realized he was facing a methodical examination of his own inconsistencies rather than the defensive constitutional discussion he had anticipated. Representative Crockett, that letter addressed different aspects of your work in a different context. Actually, Chief Justice Roberts, the letter specifically addressed my constitutional analysis of congressional oversight of federal courts, the exact same issue we're discussing today, Crockett replied, referencing the document. But let's move to another area. In your criticism of my Meet the Press comments, you suggested that challenging Supreme Court decisions demonstrates constitutional confusion. Yet in your 2019 commencement address at George Washington University Law School, you stated, "Vigorous criticism of judicial decisions, even from political figures, strengthens our constitutional system by ensuring robust democratic debate about legal principles." She displayed a transcript of the speech. You specifically encouraged political leaders to engage critically with Supreme Court decisions and said that such criticism demonstrates healthy skepticism that prevents judicial overreach. This seems to contradict your suggestion that my criticism of Millfield represents constitutional confusion. Which position reflects your actual view of political criticism of court decisions? Roberts's composure continued to deteriorate as the systematic presentation of contradictions made his earlier confident pronouncements appear increasingly untenable. Representative Crockett, there's a difference between constructive criticism and fundamental misunderstanding of constitutional principles. I appreciate that distinction, Crockett responded. That's why I'd like to address your specific characterization of my constitutional understanding. In your opening statement today, you suggested that my legal background makes me unqualified to comment meaningfully on constitutional interpretation. Yet, in this interview you gave to Legal Times last year, you stated, "We need more voices like Representative Crockett who combine practical legal experience with constitutional scholarship." Her background in civil rights law provides exactly the perspective needed for effective judicial oversight. The display of the Legal Times interview transcript created a visible stir in the gallery. These assessments of my qualifications seem fundamentally incompatible. In the span of 12 months, have I somehow transformed from someone whose background provides exactly the perspective needed to someone with a fundamental misunderstanding of constitutional law? Roberts attempted to maintain his judicial composure, but his responses became increasingly defensive. Representative Crockett, legal assessments can evolve based on new information and changing circumstances. That's certainly true, Crockett acknowledged. Evolution in thinking is natural and often valuable. But what concerns me is that today's characterizations present these positions as long-standing principles rather than recent evolutions. More importantly, these contradictions raise questions about consistency and constitutional interpretation that go beyond our personal disagreement. She organized her documents carefully. For instance, in the Millfield decision, you wrote that congressional oversight of court administration violates separation of powers principles that have been consistently recognized since the founding. Yet in your 2017 Law Review article in the Harvard Law Review, you wrote, "Congressional oversight of judicial administration has deep historical roots and represents one of the founders' key mechanisms for ensuring accountability across government branches." The display of the Law Review article created another wave of reaction. These positions aren't just personally contradictory, they represent fundamentally different interpretations of constitutional history and the founders' intent. Which understanding of founding-era principles informed the Millfield decision? Roberts's earlier confidence had completely evaporated, replaced by visible discomfort as he struggled to address the systematic presentation of his contradictory positions. Representative Crockett, constitutional interpretation involves complex analysis that may not always appear consistent to those without extensive judicial experience. I respect the complexity of constitutional interpretation, Crockett replied. That's why I focused on your own statements rather than offering my own interpretations. What we're examining here isn't complexity, it's contradiction. When the same constitutional principles are interpreted in directly opposite ways depending on the context, it raises fundamental questions about consistency in judicial reasoning. She turned to her final set of materials. Perhaps most significantly, in your majority opinion in Millfield, you wrote that congressional criticism of judicial decisions undermines public confidence in constitutional governance. Yet in your 2020 speech to the Federalist Society, you stated, "Public criticism of judicial decisions, including from elected officials, serves as a vital check on judicial power and prevents the dangerous concentration of interpretive authority in unelected judges." The final display created the most significant reaction yet, with several observers audibly gasping at the stark contradiction. These positions are irreconcilable. Either criticism of judicial decisions undermines constitutional governance, or it serves as a vital democratic check. Both cannot be true simultaneously. Roberts sat in silence for several moments, the systematic presentation of his contradictions having effectively dismantled his earlier confident assertions. Finally, he spoke, his voice noticeably less authoritative than at the beginning of the hearing. "Representative Crockett, I acknowledge that some of my positions may appear inconsistent when presented in this manner. Constitutional interpretation is an evolving process, and my thinking continues to develop as I encounter new cases and perspectives." "Thank you for that acknowledgement, Chief Justice Roberts," Crockett responded respectfully. "Evolution in constitutional thinking is indeed natural and often valuable. My concern isn't that your positions have changed. It's that today's hearing presented those positions as unchanging constitutional principles while suggesting that disagreement with them represents fundamental legal misunderstanding. She gathered her materials with quiet dignity. I believe we can have more productive discussions about constitutional interpretation when we acknowledge that even the most respected legal minds can hold evolving and sometimes contradictory positions. What matters most is that we evaluate constitutional arguments based on their textual and historical foundations rather than on the authority of those who make them. The silence in the chamber was profound as Roberts struggled to formulate a response that could address the systematic presentation of contradictions without further undermining his position. Legal scholars in the gallery exchanged meaningful glances, recognizing they had witnessed something unprecedented in the relationship between the judicial and legislative branches. Chief Justice Roberts, Crockett continued, I want to be clear that my purpose today isn't to embarrass the court or undermine judicial authority. Rather, it's to demonstrate that constitutional interpretation benefits from honest acknowledgement of evolving perspectives rather than claims of unchanging principle. When we present shifting positions as eternal truths, we undermine the very intellectual honesty that strengthens constitutional governance. She referenced her final document. In fact, your own writings have eloquently made this point. In your 2016 Harvard Law Review article titled Constitutional Evolution and Judicial Candor, you wrote, "Intellectual honesty requires judges to acknowledge when their understanding of constitutional principles has evolved rather than presenting new interpretations as historically inevitable. The strength of constitutional law lies not in rigid consistency, but in principled adaptation to new circumstances." The display of Roberts's own academic writing, advocating for exactly the kind of intellectual honesty that Crockett was demonstrating, created a moment of uncomfortable recognition throughout the chamber. Several justices who had joined Roberts for the hearing shifted uncomfortably as they recognized the irony of the situation. Roberts cleared his throat, his judicial composure strained but maintained. Representative Crockett, I appreciate your thorough research into my previous statements. Perhaps we should focus on the substantive constitutional questions rather than apparent inconsistencies in my commentary over the years. I agree completely that substantive constitutional analysis should be our focus, Crockett responded. That's precisely why these inconsistencies matter. When constitutional interpretation appears to change based on political convenience rather than principled legal reasoning, it undermines public confidence in judicial decision-making. She turned to a comprehensive analysis she had prepared. For example, let's examine the specific constitutional reasoning in Millfield. The majority opinion relies heavily on the principle that congressional oversight threatens judicial independence. Yet in your 2015 dissent in Patterson versus House Judiciary Committee, you wrote that robust congressional oversight of judicial administration strengthens rather than weakens judicial independence by ensuring public accountability and institutional integrity. The reference to Roberts's own dissenting opinion created another wave of recognition among the legal experts present. In Patterson, you specifically argued that the majority's reluctance to permit congressional oversight represented a dangerous departure from constitutional text and historical practice. The reasoning you condemned in Patterson appears to be identical to the reasoning you embraced in Millfield. Roberts's discomfort became increasingly evident as Crockett methodically demonstrated that his current positions contradicted not just his public statements but his own judicial opinions from previous cases. Representative Crockett, judicial reasoning can evolve as courts encounter new factual situations and legal arguments. Absolutely, Crockett agreed. But Millfield and Patterson involved nearly identical constitutional questions about congressional oversight of court administration. The factual situations were remarkably similar, yet your constitutional analysis reached opposite conclusions. What legal or factual developments between 2015 and 2024 justified this fundamental reversal in constitutional interpretation? The question hung in the air as Roberts struggled to identify any meaningful legal developments that could explain the dramatic shift in his constitutional reasoning. The systematic nature of Crockett's presentation had effectively demonstrated that personal consistency in constitutional interpretation mattered as much as Justice Elena Kagan, who had been observing the exchange with visible interest, leaned forward to address the situation. Perhaps we should acknowledge that this discussion has raised important questions about consistency in constitutional interpretation that deserve careful consideration by the court as a whole. Roberts nodded gratefully for Kagan's intervention while recognizing that her comment implicitly acknowledged the legitimacy of Crockett's constitutional analysis. Justice Kagan raises an important point. These are complex constitutional questions that benefit from ongoing examination and discussion. Crockett seized the opportunity to conclude her presentation on a constructive note. I appreciate Justice Kagan's observation and Chief Justice Roberts's willingness to engage with these difficult questions. My hope is that this discussion demonstrates the value of subjecting all constitutional interpretations, regardless of their source, to rigorous scrutiny based on textual analysis, historical precedent, and logical consistency. She organized her materials one final time. The strength of our constitutional system lies not in the infallibility of any individual interpreter, but in the ongoing dialogue between institutions committed to principled legal reasoning. When we examine constitutional arguments based on their merits rather than the authority of those who make them, we honor the founders' vision of a government accountable to law rather than personalities. As the hearing concluded, observers throughout the chamber recognized they had witnessed a defining moment in the relationship between congressional oversight and judicial authority. Legal commentators would later note that Crockett's methodical presentation had demonstrated how effective oversight could strengthen rather than weaken constitutional governance by ensuring accountability at the highest levels of government. The aftermath extended far beyond the immediate hearing as legal scholars and political observers grappled with the implications of what they had witnessed. Several law schools announced plans to incorporate the exchange into their constitutional law curricula as an example of how systematic analysis could effectively challenge prestigious legal authority. Within 48 hours, major newspapers published editorial commentary recognizing the significance of the confrontation. The Washington Post noted that Representative Crockett's methodical presentation demonstrated that constitutional interpretation must be evaluated on its merits. The Wall Street Journal observed that systematic analysis of judicial reasoning strengthens constitutional governance.